Laws will come to order. We're going to begin as a subcommittee since everyone's still filtering their way in. Some members have other hearings that they're attending. I'm sure some folks are still trying to make their way in due to the weather. I appreciate everyone who has made it through the weather to be here this morning. We will begin with Senate Bill 246. That's Senator Crawford. Please proceed when ready.
Thank you, Mr. Chair, members of the committee. For the record, Sandy Crawford, District 28. Thanks for the opportunity to present Senate Bill 246 this morning. I'm going to give you a very high-level overview of the bill, and then I have a couple witnesses that are going to get into the details. So 246, Senate Bill 246 is the Missouri Uniform Fiduciary Principle Act, also known as MUFIPA. This is a revision of the former Uniform Principal and Income Act, which was originally adopted in 2001. These numbers are from last year, and I don't have updated, but as of last year, 6 states had already adopted UFIPA, and 2 others were looking at it. So I don't have those updated numbers, but I bet my witnesses will. This bill will provide updated and inflexible accounting rules for trusts, for modern trusts. Current trends in estate planning allow for very long-term trusts that give broad discretion to adapt to future events. MUFIPA recognizes the new trends and updates the law accordingly. Senate Bill 246 gives estate planners the ability to tailor the terms of the trust to fit the needs of their clients. It also states that the trust is governed by the law of the state where the trustee has its principal place of administration. The bill will allow the trustees to invest for the greatest possible return, regardless if it comes in the form of an income or growth of principal. With that, I'll try to answer questions, but I have my very informative witnesses that are ready to come up and get into the details.
Thank you, Senator. Questions for the bill sponsor from the committee? Seeing none. First witness testify in support. Please come forward, make sure you filled out your witness card, and proceed when ready. I don't believe your microphone is on.
Yes. Good morning, Mr. Chairman. And
thank you.
Committee members, an honor to be here, as it always is. Appreciate the opportunity to explain some of these technicalities in the Missouri trust and estate planning laws. My name is Michael Maglieri. I have been a member of the Probate and Trust Committee for the last 40 years. And I've served as the chairman of the Trust and Probate Committee. I was the founding chair of the Estate Planning Division for the Missouri Bar, and I've served as the chairman of the Trust Committee for the last 15 years. I remember when we modified the old Principal and Income Act in 2001, and it's hard to believe that 25 years has gone by, and we need to update that law. It's, I think, vitally important. The old law was good and it served its purpose, but it really is obsolete. Back then, in 2001, we were talking about the Principal and Income Act. We were dealing with investments like mutual funds. And, they were aggressive. In the old days, people just had bonds and stocks in their portfolio. Things have really changed since then. We have asset-based securities, hedge funds, all kinds of assets. And now it looks like on the horizon we're dealing with cyber currency. And what we're talking about here, if you don't know, if you do, I beg your pardon, when you have a trust, whether it becomes irrevocable at death, or if you set up a revocable trust, it could be a grantor trust, it could be a defective grantor trust, it could be a GRAT, it could be a life insurance trust. These trusts are generally irrevocable. And so you have a fiduciary, which most of the time is a trustee, that has an obligation to file a 1041 fiduciary tax return. Those tax returns different from the normal 1040s that people are used to. That tax return would reflect trust income, and from that there would be certain deductions that the trustee could take. And then you have to take a look at the beneficiaries, and there would be D&I, which is distributable net income that would be passed out to the beneficiaries based upon their pro rata share. Many items that are in trusts, it could vary. If you, by way of illustration, if you had, and I guess most of you have trusts, and hopefully you have a qualified spousal trust, which is just passed last year, the Fourth Amendment. But when you have one of these trusts, let's say that you have disposition to your spouse, and that could be in a marital Q-tip subtrust, could be in a residuary trust. And as time goes on, those monies need to be invested properly. I'm thinking of 3 situations that are in our office right now. One of them, the trust was distributed down to the spouse and to the son, and we have, for example, a car dealership in it. And so there's a lot of receipts coming in and out, and how do we deal with that, and how does the trustee allocate income or principal to that? Of course, the reason that's important is income is taxed at a higher rate, 39% possibly, whereas capital gains would be 20 plus 5%, state of 25. So people would like to be able to make a decision. This new statute does allow us to have a lot of flexibility. The trustee can decide whether it's income or principal as long as they're consistent. And there is a definition of income and principal, as was in the old act, but there's a lot of flexibility to make different decisions based upon the facts of the case. So the illustrations, let me give you just a couple others. I don't want to take up too much of your time, but if we have another situation where father just died. He had a flooring company, and he has 2,000 head of cattle. And so it's very important that we decide how are those cattle going to be taxed when they're sold. Generally, throughout this new act, we have a 90-10 differential. If something is hard, we don't have a specific answer to whether it's income or principal, then 90% of it would be principal and 10% would be income. There are just so many situations. And of course, we may be fortunate enough to have an estate that has $1 million or $2 million in it, and we're trying to deal with the taxation of that for our spouse in a marital trust or in a residuary trust, or for children or grandchildren in subtrusts that are held in a discretionary manner. And so we really need to think that through of how those assets are going to be taxed. I can't emphasize enough, the old statute doesn't cover so many things. For example, special tax benefits. We can have subchapter S trust and somebody that has a corporation when they die that's put into a trust. We can have charitable trusts that evolve from a revocable trust possibly. And those things have to be looked at in particular manners. This power to adjust, as I mentioned, is very, very important. The old law doesn't have that. Since we passed that law, you'll recall that since 2010, we've passed the Trust Protector Act, which allows someone who's not the trustee to have authority to look over the trust and, based upon the powers that are granted in the document, make certain decisions, and that could be turning on and off grantor trust status for income tax purposes. We also have non-judicial settlements, which we didn't have back then. So this act addresses all those different particulars and will give that flexibility that we need. We can look at capital distributions for businesses, and again, as I mentioned, different receipts that may be coming in and out of different businesses. It deals with life insurance, and it even deals with mineral rights and timber, for example. So in this case that I was mentioning, the client that had the 2,000 head of cattle, there's timber there too that's going to be sold, and the taxation of that is important.
Mr.
If
Chairman,
I could interrupt here, I believe there's a question from the committee.
Oh, yeah, I'm sorry.
respectfully, talking about various kinds of assets and trusts isn't particularly helpful in understanding what is changing in this bill. Would you mind finding us after this committee hearing? There's a number of other witnesses that are waiting to testify, and I would love to hear about what this particular bill is changing, because the listing of kinds of trusts and kinds of assets that attorneys could work under their trusts already doesn't explain to me how the uniform rules would change. So let's talk after the hearing, if you don't mind.
Okay,
Thank you.
that's good. Well, I'll end. Yeah, I could go on for an hour, but I won't do that.
Well, we appreciate that. We probably couldn't indulge an entire hour, unfortunately.
Yeah.
I wish we had unlimited time. Any other questions for this witness from the committee? Seeing none. Thank you again for being here
Thank you.
this morning. Other witnesses testify in support.
Mr. Chairman, members of the committee, my name is Andy Briscoe. I'm the registered lobbyist for the Missouri Bar. We'd like to thank Senator Crawford for bringing this proposal forward. It's been brought forward a number of years. We've never had opposition on this side or the House side, and we'd just like to reiterate our support for it.
Thank you. Questions for this witness? Seeing none. Thank you again for being here. Further witnesses testify in support.
Ray Bozarth, Missouri Credit Union Association. Some of our credit unions manage trusts, so I'd like to testify in support.
Thank you. Any questions for this witness? Seeing none. Thank you again. Any further witnesses testify in support? Any witnesses here testify in opposition? Seeing none. Any witnesses here testify for informational purposes only? Seeing none. Senator, any closing remarks?
Nothing further. Thank you.
Thank you, Senator. That will conclude the public hearing on Senate Bill 246. We will next proceed to the public hearing for SJR40. Senator Carter, please proceed when ready.
Mr. Chair, members of the committee, thank you for your time this morning, and thank you for hearing our proposed constitutional amendment that will codify the office of a sheriff in the Constitution. Currently, right now, it's just an office in statute, and so what we would like to do with this amendment is just put it into the Constitution so that protection is there for them. I will give my time to those who have come so far and in the storm nonetheless to testify. Thank you.
Thank you, Senator. Any questions for the bill sponsor? Seeing none. First witness testify in support, SJR40. Please proceed when ready.
Good morning, Mr. Chair and honorable members. I'm Sheriff Mike Bonham, Osage County Sheriff. I've been sheriff since 2016. We have seen a need, and there are several sheriffs here. Not everybody will testify, so I think we'd be hitting the same points. But we have seen a movement across the country, and thank God we live in the great state of Missouri, that we have great legislators and senators right now that would not feel of changing the office of sheriff. But there is other states that have removed the office of sheriff, such as Connecticut, and it is now the state police. And then it loses the local control for local law enforcement. The sheriff's job and the sheriff's position in each county is unique to those values and culture. This bill here would protect the office by enshrining it in the Constitution. It will not create any new powers for the sheriff. It will not change anything that we currently are doing. The bill will reflect, I know there will be a couple changes along the way that we've asked, but it will reflect that the state law currently, the RSMOs in the 57s, which is the sheriff's chapter, is being carried over to this bill. And we feel it's vitally important. I would remind you, in Illinois just a couple of years ago, that the governor there threatened to remove sheriffs because they were protecting individuals' rights in their firearms, that they were trying to remove firearms from personnel, and the sheriff stood up, the majority of them, 94 if I believe is correct, and said, no, we're not going to do that, and then were threatened to lose their position by the governor by removing their license. And the same thing could absolutely happen here. Like I said, we're very fortunate. We have a very conservative, and we have a great state. I love my county of Osage, and I want to make sure that we preserve those rights for our people across the state. And with that, I'll yield.
Questions for this witness from the committee? Seeing none.
Also, I do have some letters from sheriffs that were unable to attend that I will be putting with this as well. Thank you.
Very good. Please submit those to committee, and we'll try to get those distributed to the members. Further witnesses testify in support.
Good morning, Mr. Chairman. Good morning, committee members. My name is Steve Pelton. I serve as the Franklin County Sheriff, also representing Missouri Sheriffs United and Missouri Sheriffs Association. So I just wanted to bring to light, and Sheriff Bonham done a great job. We just want to preserve the future with the office of sheriff. The role of Missouri Sheriff is more than just enforcing the law. It's about upholding constitutional rights of every citizen. As the highest ranking law enforcement official in the county, a sheriff with constitutional authority serves as the last line of defense between people and overreach. The authority ensures that law enforcement remains accountable to the people. Missouri Constitution grants sheriffs the power to protect their rights of citizens, ensuring due process, safeguarding private property, and upholding the Second Amendment. Unlike appointed officials, such as possibly chiefs, the sheriffs are elected by the people, meaning they serve directly at the will of the people. This law doesn't change, or this bill, I'm sorry, doesn't change anything with how we are elected, still elected by the people to represent the people. And at the end of the day, the sheriffs are the protectors of liberty and stand firm in people's protection. So we are testifying in support of this. I'd be happy to answer any questions, sir.
Questions for this witness? Seeing none.
Thank you.
Thank you for being here this
Ms.
morning.
Carter, thank you for bringing this forward.
Thank you.
Further witnesses testify in support. Seeing none. Any witnesses here testify in opposition? Seeing none. Are any witnesses here testify for informational purposes only? Seeing none. Senator, any final remarks?
No, just my appreciation. Thank you so much for listening to this legislation.
Thank you, Senator. That will conclude the public hearing on SJR40. We will next proceed to public hearing for SB238. Senator Berger is here. Please proceed when ready.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Jamie Berger, representing the 27th District. In August of 2017, Missouri amended Missouri Statute 490.065.2 to match Federal Rule 702 on the admissibility of expert testimony in civil and criminal litigation. In doing so, Missouri joined the majority of states that had already adopted Federal Rule 702. The United States Supreme Court unanimously adopted an amendment of Rule 702 to clarify the intent of Rule 702 and provide better guidance to courts on the process of evaluating whether expert testimony is admissible. The amendment proposed in Senate Bill 238 is a continuation of the decision we made in 2017 to adopt Rule 702. This language exactly matches the changes made by the Supreme Court to Rule 702. It is a clarification of the gatekeeping function of the courts, and we anticipate it will provide clearer guidance to our courts. A number of state courts already have taken the same action to update their state laws to match a new version of Rule 702, notably including Kentucky, Louisiana, Ohio, and Arizona. Similar proposals have also been made in Alabama and Mississippi, among other states. Again, this proposed amendment is intended to keep Missouri law consistent with the expert witness rules adopted in 2023 by the United States Supreme Court and provide better guidance to our judges in deciding whether expert witness testimony is admissible. It does not change the function of the jury to weigh the evidence that is admitted and reach its decision. I believe there are some experts who will be better suited to answer your questions, but thank you for allowing me to present.
Questions for the bill sponsor? Seeing none. Thank you, Senator, for that explanation. First witness to testify in support. Please make sure you filled out a witness card and proceed when ready.
Thank you, Mr. Chairman, members of the committee. It's an honor to be here with you. My name is Eric Lasker. I'm a partner at the law firm of Hollingsworth LLP. I'm here on behalf of Midwest Sterilization Corporation. Back in 2015, I joined with a professor, law professor at George Mason University, David Bernstein, to analyze how courts were applying Federal Rule of Evidence 702, which had at that time the same language as the expert admissibility rules in Missouri. And what we found was that there was significant confusion in the courts. Courts were applying the rule in different ways. And we published a law review article, and we brought that to the attention of the advisory committee, which is a group of judges who are charged with drafting the rules of evidence for federal courts so that courts can properly apply those rules. And that committee then went forward over an 8-year process and determined that certain clarification was needed in the rule for it to accomplish what it was intended to accomplish. Now, in 2017, Missouri passed and enacted a statute to make the expert admissibility rules in Missouri match the federal rules, and also the rules that were applicable in many states. And you accomplished a number of important things that way. You prevented litigation tourism, where people from outside the state were coming in and they were using up court space, using up court time, and taking that away from Missourians because they wanted an unequal treatment in Missouri. You also secured equal treatment for Missourian people and Missourian businesses in state and federal court. Businesses in Missouri are subject to litigation in state court. Out-of-state corporations would get into federal court, and they would have an advantage over state companies if there is a distinction between the expert admissibility rules, an important accomplishment in 2017. I think something else that you accomplished, which is very important today in society, and for me is something I kind of get on my soapbox about. There is an issue in this country with skepticism about science, skepticism about institutions, skepticism about the courts. And that faith in the courts and in science is eroded when you have situations where unreliable testimony is being admitted into court and it is resulting in huge verdicts, it's resulting in people being imprisoned who shouldn't be imprisoned, and this body in 2017 took a stand against that. Now, what you have in this situation is that the law, with the amendment of Rule 702 in the federal courts, for you to secure the goals that you sought to pursue in 2017, the statute needs to be amended because most of these advantages, most of what you accomplished in 2017 is based upon the fact that there is consistency, that there is uniformity. And if the statute is not amended to again track 702, you're going to be taking a step back. You're going to be losing a lot of what you accomplished in 2017. And that really is all that is going on here. This is a continuation of the decision that was made in 2017. And I would go back and stress the fact that the changes to the federal rule, that's not a political process. That was a decision made by judges. It was made by trial judges. And I appeared before them. I was involved in a number of discussions with them as the changes were made. They decided the language that needed to be added to Rule 702 to help trial judges. It wasn't even appellate court judges, district court judges. They decided the language that would be needed to help their fellow brethren and sisters on the court to apply the rule appropriately. That rule then went to the full advisory committee. It was a committee made up of, it had representatives of business, plaintiffs, bar, defense bar. It was approved unanimously, and as already been indicated, went up to the Supreme Court and was approved. And so what we're asking for this body is just to keep Missouri in step with what it did in 2017. Thank you.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you for being here. Further witnesses testify in support. Please proceed when ready.
Good morning. Dana Freeze, President and CEO of Healthcare Services Group in Jefferson City, testifying today on behalf of the Missouri Hospital Association. We insure over 50 hospitals throughout the state of Missouri, thousands of doctors, nurses, other healthcare providers. Just wanted to give you some perspective of where we are seeing some challenges in Missouri. We try cases all around the state of Missouri, and what we're seeing with some expert witnesses is providing testimony saying that a particular damage claimed was, quote, associated with the alleged negligent act, which is very different than what the burden of proof is, which is to prove that the alleged negligent act more likely than not caused the damage claim. Association is not causation. That's a very important element of our judicial system, and the federal rule as amended and as proposed to amend the Missouri statute provides better clarity as to what the court should permit in order for the law to be followed and the burden of proof to be met, and for juries to not be confused by association versus causation. So thank you for the opportunity to be here today.
Questions for this witness from the committee? Seeing none, thank you for being here as
Thank
well.
you.
Further witnesses testify in support. Please proceed when ready.
Thank you, Mr. Chairman and members of the committee. I want to thank Senator Berger for bringing this issue. Just to dovetail off the prior testimony, the purpose of this obviously is to conform Missouri's standards with the federal standards. In reviewing the impetus behind the federal changes, back in 2016, the National Academy of Science and the Presidential Council of Advisors in Technology critiqued the federal forensic evidence standard because it was failing to reliably establish an evidentiary standard for the submission to juries as well as courts. We're experiencing the same thing with the applicability of the existing standard. What this does is require a court to make a determination on the preponderance of the evidence on whether the expert testimony should be admissible. That is the appropriate gatekeeping function of the judge, particularly when there's a jury. And we'd ask for this committee's support and the body's support in trying to make sure that all litigants are getting a fair trial and adjudication of their issues.
Thank you for that testimony. Questions for this witness from the committee? Seeing none, thank you again for being here. Further witnesses to testify in support.
Mr. Chairman, members of the committee, Jorgen Schlemmer on behalf of American Tort Reform Association, in support.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses testify in support. Please proceed.
Rich Albishon, Mr. Chairman, members of the committee, on behalf of the Missouri Civil Justice Reform Coalition and the American Property Casualty Insurance Association. We are in support of the bill. You know, years ago we fought for 3 years to get the rule change from McDonough and Fry to what we have today, which is the Daubert standard. Quite frankly, this is just an update, so this is not the end of the world for folks that want to have the fight. And rules are meant to be improved. That's what we're here for today.
Questions for this witness? Seeing none, thank you for being here. Further witnesses testify in support.
Hi, good morning, Mr. Chair. Thank you, committee, for having us here. My name is Mark Dunn. I'm General Counsel for Midwest Sterilization Corporation. Midwest Sterilization sterilizes medical devices, just to avoid any confusion about what we do.
Appreciate that clarification.
Indeed. I also am in private practice. Midwest Sterilization is in Jackson, Missouri. I've got a part-time private practice in Cape Girardeau, Missouri. Thank you, Senator Berger, for introducing this legislation. I just want to state our wholehearted support of this amendment so we're consistent with the federal rules. And as a practitioner who in my career has been on both sides of the bar and in both state and federal court, I would deeply appreciate being able to have the same rules in the courts I go to. Thank you very much.
Thank you. Questions for this witness? Seeing none. Further witnesses testify in support.
Mr. Chairman, members of the committee, Jacob Scott with the Missouri State Medical Association and the Missouri Association of Osteopathic Physicians and Surgeons. Also want to thank Senator Berger for bringing the bill forward. When we talk about Missouri physicians and making sure that our state is one of the best states to practice medicine, this bill will really help with that. And, we're under pressure for malpractice premiums and all kinds of other external pressures, and this bill is very much helpful. So thank you for the bill. Happy to answer any questions.
Questions for this witness from the committee? Seeing none. Thank you again for being here. Further witnesses in support? Please proceed when ready.
Matthew Smith is Associated Industries of Missouri. Just want to go on record of support this bill.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses in support?
Mr. Chairman, members of the committee, Brian Bernskater here on behalf of the Missouri Organization of Defense Lawyers. Want to thank Senator Berger for bringing this forward, and we certainly support the bill.
Thank you for that testimony. Questions for this witness? Seeing none. Further witnesses testify in support?
Luke Reed, Missouri Chamber of Commerce and Industry. We're here to support Senate Bill 238 because it improves uniformity between state and federal courts.
Further any questions for this witness from the committee? Seeing none. Further witnesses in support? Seeing none. Any witnesses here testify in opposition? Please come forward. Make sure you filled out a witness card. Proceed when ready.
Good morning, Senators. I'm David Clarich, today appearing on behalf of the Missouri Circuit Judges Association in opposition to Senate Bill 238. When I saw this legislation introduced both in the House and the Senate, the first thing that was brought to mind was 2016, 2017, when this issue was litigated before you in a heated battle is trying to impose the Daubert standard at the state level. And the interesting thing was the debate at the time was the role of the courts. And it was interesting to hear 11 witnesses in favor of this legislation talking about the trial judges and how this was intended to both clarify our existing laws and assist the trial judges in rendering decisions. The Missouri Circuit Judges of the state have a different opinion because, as you are aware, we're not the federal courts and we don't have clerks. We don't have clerks to make our decisions on our behalf or assist us in making our rendering expert witness testimony credibility and weight. We have to rely upon the juries to do that, which was presupposed by our Constitution. Weight and credibility issues should be weighed by a jury and not by your circuit judges. We don't have the capacity to do that. And so this reopens that issue. And at first when I saw this, I was trying to figure out what it did, and I sought one of the proponents, lobbyists, to help clarify, and it was supposedly just a reflection, they said, of the Federal Rules of Evidence 702 and 703. As I looked at those rules, in fact, it kind of was, but as you know, when the legislature acts, it has meaning, and it has to be interpreted as such. And what we found as we began to investigate further, and as we began our discussions regarding what its implications might be, we see that shift from the jury to the judges, and that, I think, is not in the best interest of our judicial system, certainly not in the best interest of your courts rendering decisions, and I think contrary to the constitutional principles upon which we stand. So until we can be assured to the contrary, we stand in opposition to this legislation.
Thank you for that testimony. Questions for this witness from the committee? Yes, Senator Coleman, proceed.
I just want to thank you for your zealous representation of your client. I always like hearing adopting the federal rules as undoing democracy. Like, that's always really fun to hear the catastrophic response that will happen if we do that. So that, just a quick comment. Thank you.
No, Senator, I get that. And in fact, if you recall, in 2016, we had that discussion, what the implications of having, you see.
Thank God 2016 was before I arrived. Thank you, though. I wasn't trying to, I was just being silly. I apologize.
Thanks, Senator.
Further questions for this witness or general comments?
Yes.
Seeing none, thank you for being
Thank you,
here.
Senator.
Further witnesses testify in opposition. Please proceed when ready.
Thank you. Mr. Chairman, members of the committee, my name is Lou Ann Madsen. I'm a registered lobbyist for the Missouri Association of Trial Attorneys, and much like Mr. Clarich represented, the association was involved in those conversations, and we are not convinced that these changes are needed, and so that's kind of where we are. Same reasons, shifts the burden away from the jury to the judge. So for those reasons, we're opposed.
All right, thank you for that testimony. Any questions for this witness? Seeing none, thank you for being here. Other witnesses testify in opposition. Seeing none, any witnesses here testify for informational purposes? Seeing none, Senator, any final comments?
No, thank you for allowing me to present.
Thank you, Senator. That will conclude the public hearing on Senate Bill 238. We will proceed to yes, we will very quickly pause and take the roll. Madam Secretary, please call the roll.
Senators Trent, Gregory, Bernskoetter, Carter, Coleman, McCreary, Weber.
All right, a quorum having been established. We will now proceed to the public hearing for Senate Bill 225. Senator Coleman, please proceed when ready.
Thanks so much, Mary Elizabeth Coleman, State Senator for the 22nd District representing Jefferson County. This is a bill I've carried for many years, and I'm really proud to be presenting it today. Missouri is one of just 8 states that allows, when there is non-unanimous decision in a capital case, for the death penalty to be applied by a judge. I think that the death penalty is an appropriate punishment for the state of Missouri when there are heinous crimes that are committed that are outlined in statute. I am full support of that. But I have deep concerns that the way that we apply the death penalty is not consistent. And so when it is inconsistently applied, that sounds to me like an unusual application. And so therefore I have concerns about the constitutionality of how we're applying it. I think that this moves us a step forward to make sure that we are, as a state, constitutionally applying the death penalty by consistently applying it, no matter who the defendant is or what the rules are. And so eliminating the judge's ability to use their discretion to apply the punishment of death of the defendant, I think, is a step forward that would make us have a more fair application of this strong power that the state has to enforce the public good.
Thank you for that presentation. Questions for the bill sponsor from the committee? Seeing none. Witnesses here to testify in support. Please proceed when ready.
It's going to be fine. I promise this isn't a play for sympathy. I have laryngitis, but Sharon Galway-Jones here today on behalf of Missourians to abolish the death penalty. This is a moderate spot in between complete abolition and what we have now, and because of my voice, I won't go further into detail. But I do think we may actually be down to 2 states.
Oh, I'm sorry, my notes are from
Oh, are they right?
2018,
Okay.
So no, you're right.
I think we might be down to 2 states that do not require a unanimous jury verdict. So thank you very much for bringing this, and thank you for hearing it.
Thank you for that testimony. Questions for this witness?
No. I don't.
Seeing none, if you would like to submit any further testimony by writing, please feel free to do so. Hope your voice gets better soon. Further witnesses in support.
Thank you, Mr. Chairman, members of the committee. Samuel Lee. Today I'm not representing I am a registered lobbyist, but I'm testifying on behalf of the Archdiocese of St. Louis Peace and Justice Commission, of whom I'm a member. I have written testimony here, which I also send to all the committee members, so others who aren't here can see that. And I'm not going to read that, except that the position of the Catholic Church is very clear, is just opposition to the death penalty. That is a position which has developed over the last number of decades to be complete opposition. Some decades ago, there was some wiggle room, so to speak, but as of 2018, the Catholic Church's position is that the death penalty should be abolished. But that's not what this bill does. What it does do is saying that jurors and not judges get to decide. And we think that's perfectly reasonable and consistent with the Missouri Constitution, in particular Article 1, Section 5. And I'll explain that by giving an anecdote. It's a personal anecdote. Many years ago, decades ago, I live in St. Louis County, and I was called to be on a jury, and it happened to be a capital murder case. The man was charged with killing multiple people in a family. I think it was a domestic dispute of some sort. During voir dire, I was asked of my position if the defendant was convicted, would I be willing to impose or not the death penalty. Of course, I answered no, I would not. And if I recall, the defense attorney was Scott Rosenblum, and he tried to rehabilitate me, and I said no, I wouldn't do that. So I was dismissed from the jury. And looking back on that, and looking at Article 1, Section 5 of the Missouri Constitution, which is sometimes called the Prayer in School Amendment, but it's much, much more than that. Jurors cannot be dismissed from a jury because of their religious beliefs. And I'm not saying that to complain. I'm just saying that what jurors say in terms of what the penalty should be, I think should hold true. And if it's not unanimous, then I think a judge should not be able to impose the death penalty. And I think that's basically my testimony, Mr. Chairman. I'm also, the Catholic Conference is going to be here because of the weather. They couldn't make it, but with their permission, I've got a written statement. I'm testifying on their behalf as well.
All right, thank you for that testimony. Questions for this witness from the committee? Seeing none.
Thank you.
Further witnesses testify in support.
Mr. Chairman, members of the committee, Brian Bernskater here on behalf of the Missouri Association of Criminal Defense Lawyers. We have a longstanding policy against the use of the death penalty. We certainly appreciate this step in the right direction.
Any questions for this witness from the committee?
Thank you.
Seeing none. Thank you for being here. Further witnesses in support. Please proceed when ready.
Thank you, Senator. Good morning, Jeff Stack, registered lobbyist with the Missouri Fellowship of Reconciliation. Appreciate Senator Coleman's ongoing leadership on this measure. This is a common sense effort. We are indeed opponents of the death penalty across the board, but this is a case where it's helping to support the fidelity of the jury system. If a group of 12 jurors who are death qualified, as Mr. Lee was mentioning, if they can't agree that death is warranted, then we should just go with life without the possibility of parole. It's a pretty harsh sentence. It's no being soft on criminals. I think the other thing to think about here is we've been over the years. There are cases where we find that we find just the power of the jurors. In '83, Ellen Reasonover was convicted. She was facing the possibility of a death sentence. 11-1, the jurors voted in favor of the death penalty. The one lone juror proved to be the person who was really key because she was later found to have been not guilty, so she could have easily been executed. I think we have to appreciate jurors of our peers. This is so fundamental to our democracy, and I appreciate so much, Senator, you all hearing the bill today. I sure hope that soon it gets voted, do pass, and move forward. So thank you very much. I'd be glad to answer any questions.
Questions for this witness? Yes, Senator
Could I make a
Weber,
brief
please
comment,
proceed.
Mr. Chair? This is kind of a cool moment. I don't know if, at least for me, I don't even know for anybody else. But one of the issues that I've changed my mind on over the years was the death penalty. And I changed it in high school when I wrote. I had to write an article on it, and I had to go do some research. And I talked to people in the community to get both sides. And one of the people I talked to who really changed my opinion on this was Jeff Stack. And Jeff, you've been working on this. I was probably 14, 15 when I talked to you about this. It's 27, 28 years ago. And you're the reason that I've changed my opinion on it. And I really appreciate and respect your consistency. You've been fighting this for a really long time. And so it's really a kind of a trippy thing to be up here on a Senate committee listening to you talk about the same issue you talked about to me when I was just a kid writing a paper for school. And so I just wanted to take a minute and tell you that and just say that it really means a lot to me, and I appreciate it.
Thank you kindly, Senator Weber. I, too, used to be a strong supporter of the death penalty. But I started meeting the human beings who we sentence to death and realizing they are human beings. And so we need to move beyond the idea of figuring that folks are monsters. You know, they've committed monstrous deeds, but they still have that kernel of humanity. And so we deserve to respect that in them. And not mimic the horrible deeds that they committed by killing them. Thank you.
Further questions for this witness? Seeing none. Additional witnesses testify in support. Please proceed.
Good morning, Mr. Chairman, members of the committee. My name is Jeremy LaFavor, appearing today on behalf of Empower Missouri. I'm not sure that I can add much more to the great testimony we've had. We want to go on record in support. We appreciate the Senator's leadership.
Questions for this witness? Seeing none. Thank you again for being here. Further witnesses testify in support. Seeing none, are any witnesses here testify in opposition? Seeing none, are any witnesses here to testify for informational purposes only? Seeing none. Senator, do you have any closing remarks? That will conclude the public hearing on Senate Bill 225. The committee will pause for just a moment here as we are expecting another member to show up. All right. The committee will resume, and I move that we go into executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Aye. The ayes appear to have it. The ayes do have it. We're in executive session. I next move that we bring Senate Bill, we will move that we bring Senate Bill 168 before the committee. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. The bill is before the committee. There is a Senate committee substitute that has been distributed, and the Senate sponsor is here. Would he care to explain the committee substitute briefly?
After we initially brought before the committee the squatters bill, there was a couple different people, senators and representatives, came to me, thought we need to add commercial vacant buildings to the language and also vacant land. Basically, someone had pitched a tent somewhere on some vacant land, and they had a hard time getting that person off that land. So that's the idea of adding these two more descriptions. Thank you.
All right. I move that Senate Committee substitute for Senate Bill 168 be adopted. Is there any discussion on that Senate Committee substitute? Yes, Senator, please proceed.
Thank you. Directed at the sponsor, we did what this bill that we're looking at right now, 168, is trying to address is just an expansion of a bill that just went into effect last August. So we don't even know if that's working. You know, we don't have any data. I'm not exactly seeing why we need to increase penalties on a bill that just went into effect a few months ago. So just wanted to put that out there to see if you have any logical reason for why we're doing this right now.
You know, I still think there's a difference because the bill that Representative Brown passed last year in the House, and I don't know who was the Senate sponsor, I don't know who it was, but basically they're paying.
Curtis.
Okay. That guy right there.
He's got all my favorite bills.
They were paying rent, and it's an eviction notice. These people are squatting. It's completely different. These people, if you leave your house to go on vacation for a week and you come back and they have moved in, this is to get them out of there. Squatters,
Okay.
not renters.
And that's happening in Missouri?
Yes, it is happening in Missouri. Matter of fact, it happened in Cape Girardeau.
Huh, interesting.
Yes.
All right. I'd like to learn more about that, but I will
Okay.
do that at a later time.
Okay,
Thanks.
thank you.
All right. Further discussion on the motion to adopt the Senate Committee substitute. Seeing none, all those in favor of adopting Senate Committee substitute for Senate Bill 168, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. You've adopted the Senate Committee substitute. I next make a motion that the committee vote do pass Senate Committee substitute for Senate Bill 168. Discussion. Seeing none. Madam Secretary, please call the roll.
Senators Trent,
Aye.
Gregory, Bernstetter, Carter, Coleman, McCreary, Weber.
By your vote of 3 aye and 2 no, you have voted do pass Senate Committee substitute for Senate Bill 168. I next make a motion that we leave executive session. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. If any opposed, say no. The ayes appear to have it. The ayes do have it. We are out of executive session. No further business coming before the committee. I make a motion that the committee adjourn. Do I have a second? It's been seconded. All those in favor, please signify by saying aye. Any opposed, say no. The ayes appear to have it. The ayes do have it. Committee is adjourned.